Your smartphone contains your entire life: messages, photos, bank accounts, location history. If police arrest you, can they search your phone? Many Americans assume officers can simply unlock it. That assumption is wrong. Digital privacy law has evolved rapidly. Welcome to Rights and Reality USA. This episode explains what police can and cannot do with your device. Your phone is a portal to your private world. Tonight, we explore the constitutional rules that guard it and the exceptions that test those limits. At the very core of the discussion about police searches of your phone, the Fourth Amendment. This amendment acts as a shield protecting individuals from governmental intrusion. It establishes your right to be secure in your persons, houses, papers, effects, against unreasonable searches and seizures. This means the government, including police officers, cannot arbitrarily search your private property without valid legal justification. It is a fundamental check on state power. The Fourth Amendment sets a default rule. Law enforcement must first obtain a warrant. A warrant is not just a piece of paper. It is specific legal authorization, granted by a neutral, detached judge or magistrate. To get a warrant, an officer must demonstrate under oath there is probable cause that a crime was committed. The modern legal framework governing cell phone searches was decisively shaped by the 2014 Supreme Court case, Riley v. California. This case did not arise from a complex technological dispute, but from a routine traffic stop. David Riley was pulled over for driving with expired registration tags. During the stop, officers discovered his driver's license was suspended, and they impounded his car. An inventory search of the car revealed 2 concealed firearms. Riley was arrested, and as part of the arrest, an officer seized the smartphone from his pocket. The officer proceeded to search through the phone's digital contents without a warrant. On the device, the officer found videos and photos that seemed to link Riley to gang activity and a prior, unsolved shooting. This digital evidence was used to charge Riley with more serious crimes, leading to a conviction and a lengthy prison sentence. Riley's lawyers appealed, arguing the warrantless search violated his Fourth Amendment rights. While the Riley decision established a strong general rule requiring a warrant to search a phone, it is crucial to understand that this rule is not absolute. The law recognizes several specific situations, known as exceptions to the warrant requirement, where police may be able to search your device without first obtaining a warrant from a judge. Understanding these exceptions is just as important as knowing the general rule itself, as they represent the legal pathways through which law enforcement can access your digital life. These situations are narrowly defined, but they can have significant consequences for your privacy. The most common and powerful exception is consent. If a police officer asks for permission to search your phone, and you voluntarily grant it, you have waived your Fourth Amendment protection for that search. Consent must be given freely and voluntarily, not as a result of coercion or duress. For example, if an officer says, "Let me see your phone," and you unlock it and hand it over, a court will almost certainly find that you consented to the search. This is why asserting your rights, which we will discuss later, is so critical. Granting consent effectively gives law enforcement a green light. The legal protections surrounding your phone often hinge on a simple, practical barrier: the lock screen. The legal protections surrounding your phone often hinge on a simple, practical barrier: the lock screen. How you secure your device, whether with a traditional passcode or with modern biometrics like a fingerprint or a facial scan, can have profound legal implications that are still being debated in courts across the country. The method of unlocking intersects with another constitutional protection, the Fifth Amendment, which protects you from being compelled to be a witness against yourself. This distinction between what you know and who you are is at the heart of the evolving law on unlocking your phone for law enforcement. A passcode, which can be a string of numbers, letters, or a pattern, is generally considered to be testimonial in nature. This means that revealing your passcode is equivalent to revealing the contents of your mind. It is a piece of knowledge that you hold, because the Fifth Amendment protects you from being forced to provide self-incriminating testimony. Beyond the data stored directly on the physical memory of your phone, your digital life extends into the vast interconnected network of remote servers commonly known as the cloud. Your photos, emails, documents, backups of your entire device are often stored on servers owned by third-party companies. Furthermore, your phone constantly communicates with cellular towers, generating a detailed log of your movements known as cell site location information, or CSLI. The question of how the Fourth Amendment protects this data, which is not physically in your possession, has been the subject of another landmark Supreme Court case. For decades, the third-party doctrine held that information voluntarily shared with a third party, like the phone numbers you dial, which are shared with the phone company, was not protected by the Fourth Amendment. The logic was that you gave up your expectation of privacy by sharing it. However, in the 2018 case Carpenter v. United States, the Supreme Court significantly limited this doctrine in the context of modern technology. Knowing the complex legal doctrines surrounding phone searches is important, but it is equally vital to know how to apply that knowledge in the real world during a stressful police encounter. The steps you take in those first few moments can have a significant impact on the outcome. The most important principle is to remain calm and composed. An officer-citizen interaction can be tense. Staying level-headed lets you think clearly and assert your rights without escalating. Do not argue. Resist. Become confrontational. Be polite. Be firm. Be clear. Explicitly and unambiguously state you do not consent to a search of your phone. Clearly state, I do not consent to a search. Police are not required to inform you of your right to refuse consent. If an officer asks, "Can I see your phone? Do you mind if I look through your messages?" In the context of a police encounter involving your smartphone, it is essential to understand the legal distinction between a seizure and a search. These two actions are governed by different rules and have different implications for your rights. While they often happen in sequence, they are not the same thing. A seizure occurs when the police take possession of your property, interfering with your right to control it. A search occurs when police examine that property to look for evidence. It intrudes on your reasonable expectation of privacy. During a lawful arrest, police can seize property on your person, including your smartphone. This is done to secure the scene and to prevent the potential destruction of evidence. The law surrounding police searches of cell phones is a testament to how our constitutional rights adapt to the technological realities of a new era. We have moved from a world of physical papers and effects to one where our entire lives are encapsulated in a digital device that fits in our pocket. In this landscape, the fundamental principles of privacy and due process remain as vital as ever. The Supreme Court has made it clear, police generally need a warrant to search your phone. This powerful rule, established in Riley v. California, treats your smartphone as a virtual home, deserving of the highest level of Fourth Amendment protection. However, this protection is not a fortress without gates. Exceptions exist, and the most significant one is your own consent. Voluntarily agreeing to a search or unlocking your device for an officer effectively waives your rights. The evolving legal landscape around biometric unlocks, the use of your fingerprint,